Recent judgment. Constitutional law. State of Haryana versus Jagdish. AIR 2010 SC 1690 2010 CR LJ 2398 2010 AIR SCW 2178. Law point. Whether the policy which makes a provision for remission of sentence should be that which was existing on the date of the conviction of the accused, or it should be the policy that exists on the date of consideration of his case for premature release by the appropriate authority. Question mark. Para facts. The respondent was convicted under sections 302, 148 and 149 of the Indian Penal Code and sentenced for life imprisonment. Having served more than 10 years imprisonment, the respondent approached the High Court as, in spite of having undergone the sentence as per the policy of the government, his case for premature release was not being considered in view of a new policy on short sentencing. Full stop. The High Court held that the case of the respondent for premature release was to be considered in the light of the short sentencing policy existing on the date of his conviction, and directed the state authorities to consider within a period of 1 month his case for premature release. Full stop. Aggrieved thereby, the state government preferred appeal before the Supreme Court. Full stop. Para. Decision. The Supreme Court held that the case of the respondent was to be considered on the strength of the policy that was existing on the date of his conviction. Full stop. The power of the sovereign to grant remission is within its exclusive domain, and it is for this reason that our constitution makers went on to incorporate the provisions of Articles 72 and 161. Full stop. The act of remission of the state does not undo what has been done judicially. Full stop. The punishment awarded through a judgment is not overruled, but the convict gets benefit of a liberalized policy of state pardon. Full stop. Even if a life convict does not satisfy the requirement of remission rules or short sentencing schemes, there can be no prohibition for the president or the governor of the state to exercise the power of clemency under the provisions of Articles 72 and 161 of the Constitution. Stop.